I'm trying to get live on all the platforms. Give me a minute. Okay, can everybody see me? Can everybody hear me? Good morning. Good morning, everybody. Can you believe it? We're literally approaching the last 2 days of the month. This year is going by so fast, so fast. Anyway, let me introduce myself. My name is Aisha Chidole. I'm an immigration attorney. I help clients in all 50 states of the United States with their family immigration matter. If you'd like to immigrate to the United States, I'll be happy to assist you to see if you qualify, to get a green card or to ultimately get your citizenship and live the American dream. If you're tuning in for the first time, definitely say hi in the comment and let us know you're tuning in for the first time. If you've not followed, if you don't follow me on either YouTube or Facebook or Instagram, definitely hit the like button, smash the like button, subscribe to my channel so you're notified every time, and subscribe on Facebook. I actually have a giveaway, back to school giveaway happening that I'm going to be posting later today. So if you have kids that are going back to school, definitely be on the lookout for that, for your chance to win. So today I want to talk about, conditional green cards. And conditional green cards is something that confuses a lot of people. So today I just really want to try and break it down to you guys. So let's start with, what is a conditional green card? What's the difference between a conditional green card and a regular green card? So normally, a regular green card is basically your legal permanent resident status, which you get for 10 years. And so once you're a green card holder, you have your green card, unless you commit certain offenses, right? And then after your green card expires, after 10 years, you can renew it. Or if you're eligible for citizenship, either the 3-year mark or the 5-year mark, you can apply for citizenship. But a conditional green card, and if you guys see me going up and down, I just have 2 screens up, so I'm trying to, pay attention to both people. As always, wow, Tiffany, thank you for tuning in from Bahamas. Thank you. Good morning, Mr. Tusk. Good morning. Good morning, guys. Definitely your questions in the comment box. I will definitely answer as many of them as I can when I finish talking about this topic. So as I was saying, with a conditional green card, what essentially you get is a 2-year green card. So what determines whether you're going to get a permanent green card or a 10-year green card? What determines this is, at the time you are approved for a green card, what or how long you have been married. So if you've been married for under 2 years, when you're approved for a green card, you will get a conditional green card. If you've been married for more than 2 years, when you're approved for your green card, you will get a permanent green card. Okay, so I just want to talk now about removing conditions when your spouse is not available, meaning you and your spouse have issues, you and your spouse have divorced, your spouse has passed away, or different things like that. So normally, to remove the conditions of your green card, you have to come with your original spouse that filed that green card for you, and you got to remove the conditions. This process is much more, in my opinion, more stringent, more difficult than getting your basic green card. Let me repeat that. Removing the conditions of your green card is tougher than getting your basic green card. Why? Because when you're getting a basic green card, they make certain, they're more lenient with documentation that you don't have, because they figure, okay, you're not a green card holder, you don't have Social Security, you don't have work permit yet, or your stuff is pending. So you might not have stuff, your marriage is young, so you might not have acquired things, you might not have acquired bills, you might not have acquired material possession, to show that you and your spouse have a legitimate marriage. But by the time they're making a decision on your conditional green card, you should have been married for 4 years at least. And they expect, or 3 to 4 years, they expect that in that time, 1, you've been married for a longer period of time. 2, Now you have your social security number. Now you have a green card to work. Now you have a green card to travel and do whatever. So you should have more stuff to prove that your marriage is real. So that is why it's more stringent. And that's why, I keep telling you guys, listen, you better have more bona fides, to show that your marriage is legitimate when you have a conditional green card and you're trying to remove the conditions. So the way you remove the conditions, like I mentioned, is with your spouse. But you know what? Life happens. Sometimes you and your spouse divorce. Sometimes you have a spouse that's extremely cruel to you, extremely toxic, extremely abusive to you, or God forbid, your spouse passes away, So USCIS allows exceptions in those situations or in those scenarios. However, you have to provide proof of why you need that waiver from your spouse. So the first one being if your spouse passes away. If your spouse passes away, you're going to, of course, need a proof of death decree that your spouse has passed away. So I said death decree, death certificate that your spouse has passed away, but you're still going to need to prove that while your spouse was alive, that you had a bona fide marriage. So think about all the things that I talk about all the time about proof of things that you need to show legitimacy of your marriage. Get all those things. They're going to be counting from the time after you got your green card. So don't start giving them things from when you were dating, or when the things that you submitted for your original marriage-based case. They want to see, so if your green card, your conditional green card is expiring on January 2000, you received your conditional green card on January 2019. The evidence you want to submit is evidence from January 2019 to January 2021 when you're submitting your application. Okay, so you want to make sure you're submitting new evidence to show the legitimacy of your marriage. Now, outside of your spouse passing away, there are two other exceptions. Well, there's a third exception, which is hardship, but I never really talk about that just because it is incredibly, let me emphasize that, difficult to be approved on hardship, saying that you're going to have so much hardship, because it's not regular hardship in your country that, I don't have money or I don't have a job. You have to show extraordinary hardship. So the other two options are if you and your spouse divorce. Similar to if your spouse passes away, you want to show that the reason for, that your marriage did not work out, but even though your marriage did not work out and you got divorced, that, you had a legitimate marriage. So evidence the same. Still got to show your legitimate marriage, but you also must show your divorce decree. If you file in there, say, because, me and my wife are filing for divorce, they're not going to make a decision on your case if you've not officially divorced. So you must officially divorce. And if you submit it before the divorce, but your divorce is a motion or whatever it is, usually by the time it gets your case, they will send you a request for additional evidence for the divorce decree and give you about 8 to 7 days to finalize it so you can send it to them. Now, the third option is extreme cruelty or abuse from your spouse. If your spouse is abusive to you, your spouse is extremely cruel to you, that is another option and another way for you to remove the conditions in your green card. You still, again, have to show the bona fide nature of your marriage. If they approve you based on extreme cruelty, usually what happens is that you will become eligible for citizenship, after 3 years. So counting from the date that you first initially received your conditional green card. Now, when you do a normal vow case, and in a normal vow case, and when I say normal, I mean a case where the person being abused doesn't have a green card or anything like that. There's more of a leniency or an acceptance of what they don't have because they don't have papers. They don't have a social security. They don't have a work permit, right? And there's fear. There's a lot of fear going to the cops, if to report your spouse. When you're a conditional green card holder, you're expecting more documentation. Now, is it possible to to get approved without the without a police report or psych evaluation. If you have other solid evidence, yes, but it's much more difficult. The standards are much more high. So I always recommend, if you're saying that you're dealing with extreme cruelty, that your spouse has affected you psychologically and mentally, you better be getting a psych evaluation. You better be getting a psych evaluation. You better go see a therapist, okay? If you are affected mentally, you better go do that. If your spouse is physically violent to you or throwing your things out or whatever, call the cops, because you know what? You can't get deported, right? Because you have a green card. So the excuse of fear doesn't necessarily apply here. So you want to try and get that to push your case forward as best as you can. So again, if you're requesting an exception, we must have detailed explanation, declaration, affidavit, what happened, why you're requesting that. So similar to a valid case, your statement is a really good opportunity to explain to the officer what is going on, or whatnot. Now, with conditional green cards, sometimes a good explanation will waive your interview, right? If you have good evidence, good explanation, good bona fides, they can approve you without your interview, which is great for most people. Otherwise, if your stuff is scanty or whatever it is, and they need to hear from you, they will schedule you for an interview, they will schedule you for an interview, and those interviews are tough. I'm not going to sugarcoat it or lie to you guys. Conditional green card interviews are tough. So you want to be prepared, to be able to, explain to the officer what happened in your marriage, articulating yourself, thinking about what you're going to talk about before you attend the interview, and not just get to the interview and say, well, things didn't work out. Okay. So that is how you remove your conditions without your spouse. All right. I'm going to take some questions. I see questions. Let's go. Let me take some on Instagram. Okay, Zanlaila on Instagram says, hi, good morning. Thanks for assisting us on the platform. I got a 2-year green card. I submitted more evidence, which wasn't a lot, to be honest. I only got 1 year. Can you explain the 1-year extension? Not sure I understand your question. So if you submitted your 2-year green card, typically what you get is an 18-month extension, not a 1-year extension. You get an 18-month extension from the time your green card is supposed to expire. Now, if you are one of those who submitted your green card late, meaning by the time they give you a filing receipt, the 18-month extension would have expired. So let's say your green card expired in 2019 and you're still just submitting now. Listen, I have clients who their green card expired like 10 years ago and they're just submitting now. They're very lucky to have, skated under the radar and not been a removal. But, you definitely don't want to wait that long. But if you wait that long and you don't have a removal, you definitely want to get on it, right away. So if your 18 months has passed, you will only get 1-year extensions. So they will just continue to, well, you have to schedule an info pass to get a new stamp when that 1 year expires, and they will just continue to extend it until they make a decision on your case. Okay. All right, let's go to Facebook. Good morning, MK Cash Money. Good morning, Chucks. Mr. Tuss, good vibes. Thank you. Okay. So what are some examples of social media interactions that can be used as marital evidence? Excellent question. This is such a good question. So social media interaction, if you and your spouse, you go out or whatever, anniversary, all of those things, and you post it on social media, right? And people comment. So I always say that when you're posting or sending social media as evidence, make sure you're screenshotting the comments as well. Because if your commentators or the people commenting are acknowledging your relationship, that is also validating it, because it means that people who you consider your friend know that this person is your spouse. So any of all those help. Or if your spouse gives you a shout out, or if they tag you in something, I love my wife, happy anniversary, blah, 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 but get those comments in there, get those comments. So when you're screenshotting, get the comments so that they can see, look, other people even know we're married, and that's why they're commenting. Now, don't go on social media talking about single living free or single and living it up if you're married, because now USCIS checks your social media, especially if you're consular processing. With consular processing, you actually have to give them your social media handle. So just so you know, consular processing is if you're filing for somebody outside of the country, that person must give all their social media platforms and handles. So you want to be very careful what it is that you're putting on there. Okay. Paul Francis says, good morning. Good morning. Good morning, Kogmotsu. I'm glad to see you back. Good morning, Amelia. Okay, let's see. Good morning, ma'am. My husband and I filed an I-765 with all relevant documents. I was given 18 months extension. The 18-month extension expired this month, and I did the info pass. I was given another 1-year extension this month. I'm so worried. What is the hold that they can approve me for the 10-year? Okay, so JD, what JD is actually asking is not an I-765. He's actually asking about an I-751, which is removal of conditions application. An I-765 is for a work permit. So that's wrong. But that is standard. There's no holdup. That is standard. You know the reason why USCIS is now giving 2-year work permits? Because there is a lot of backlog. There is a lot of backlog with the world of immigration. So most people are going to most people don't get a decision before 18 months. So, there are people who get decision between 18 months, and we cartwheel and dance, and we're super excited about it. But the norm is that it takes that long. And one of the ways to check the processing time is to always check. You can always check the processing time on USCIS based on your service center to see what month they're processing. But also keep in mind that even though that's what they process, sometimes you might just be lucky. An officer will just say approved, so that can happen. But because you've been extended for 1 year, don't be worried. They're still working on your case. And the most important thing is you're still a green card holder. Okay. Chan says, good morning, beautiful. Well, thank you. What are the benefits of a VAWA approval? The benefits are so much. So the first benefit, of course, of a VAWA approval is you get to stay in America. Who doesn't want to stay in America? If you're filing for VAWA because you live in America, you want to be able to stay here. Second thing is you get a work permit. Okay. And I'm going to assume that you're saying VAWA approval with a green card approval or VAWA approval alone. Well, let's talk about VAWA approval alone first, and then I'll talk about with the adjustment of status. So VAWA approval alone, meaning your actual VAWA case was approved, so you get a green card. You get a green card. You get a work permit that can be renewed. There's deferred action, meaning that you're not going to be deported. Your children are covered under that. So if you get approved and you have children under 21, your children are covered, whether or not they ever lived with you and your abuser. Whether or not they live outside the country. And then if you are eligible for adjustment of status, at that time you can file for adjustment of status if you didn't file originally. But if you qualify to adjust your status, I always recommend you file your VAWA at the same time as your adjustment of status, because then if you do the two together, you get approved. Your approval means you get a 10-year green card. That is the ultimate benefits of it. That's number one. And then number two, you become eligible for citizenship after 3 years. Even if you and your husband are divorced, you don't need to wait 5 years to file for citizenship. You become eligible. So for a lot of people, being a green card holder is the ultimate benefit for filing and getting an approved VAWA, and also for their children to become approved of their VAWA position and their green card. So if you, let's say your children are outside of the United States and you file VAWA and adjustment of status, and then you got approved for your VAWA, you can then continue the process with NVC and do the consular processing for your children, and they will get their green card and they can come here. So those are the benefits. Is it true USCIS will still scrutinize your removal of condition all over again when you file for citizenship? Absolutely. Listen, guys, let me tell you that USCIS is literally Fort Knox, CIA, FBI, citizenship. I think I said this last week. The most easy application, but the most difficult thing to get. Like, because that is the golden throne, that is the end all be all. Because, once you become a citizen, you can vote, you can do whatever, you're not, if you get into a crime, you're going to jail, but you're not getting deported. So they look at your entire history to catch any mistake. And especially if they gave you a green card incorrectly, or if you lied like years ago on, let's say, like your visiting visa, and said you had children, or you said you didn't have children, and then all of a sudden you want to put the children in your citizenship application. So yes, they do scrutinize it. Now, ultimately, as long as you have your stuff together, you will get approved, and you pass your civics test, you'll get approved. But never think that anything that you told before is not going to come up. So your story and whatever it is needs to be consistent. Okay. Dejan says, I need you to be my immigration lawyer. Sure. Call me 47995-6567. I would love to help you. Let's see what else we have here. Oh, somebody said tomorrow is my appointment with you at 11. Awesome. Can't wait to chat with you. Let me see, what else am I missing? Do you think a DACA deal will be made with this new administration? Actually, Gonzo, I do think so. I know this Texas, judge is being all crazy and stuff like that, but I think so. I think, was it yesterday or 2 days ago, this new citizenship, I don't want to get you all excited because nothing is confirmed yet, but this is one of the things that President Biden has pushed to the forefront. Like, this is serious for him, which is citizenship or immigration reform related to a path to citizenship. This is something that we talked about at the beginning of his administration that he wanted to do for people who were in the country from January, as of January 2nd, 2021. So if you were here prior to that, anybody that came after that, you don't qualify for this. He is serious about it. I don't want to get excited, but he has told Congress to put this on the agenda because he wants to discuss it. So y'all, if you're a praying person, you need to be fasting and praying that this stuff goes through, because if this goes through, it's going to change many lives, change many, many lives, and if they're putting that on the table, better believe DACA and CPS is going to be on the table, because these are things that he has put the budget for and he wants a decision on. So don't want to, make y'all super excited yet, but I'm hopeful. Dorothy says, good morning, Aisha. When you give all your documents to your lawyer, how do we know it's been submitted? Do we get something to say it's been submitted? How long do we wait to get an answer? Dorothy, you need to talk to your lawyer then. I mean, this shouldn't even be a question you should be asking on live. You should know it's been submitted because your attorney should have told you it's been submitted, and you should get a filing receipt, which your attorney should give you. So, in our office, our clients know when their documents has been submitted because we notify them. We give them a copy of their filing receipts, both on their client portal, and we mail them another copy. So, and give tracking information when requested. So please contact your lawyer if you don't know if your case has been submitted, just to find out. Okay. Let's see. Okay, so Abe, is it Abe says, if someone is fighting on VAWA on green card marriage, how possible? Oh, do you mean if someone is filing a VAWA green card based on marriage, how possible is it 50-50 chance or a guarantee? Oh, that is a question I can't answer. I can't answer the question because I don't know what you filed. So, the only way to know what your chances are is for your case to be evaluated and the evidence reviewed of what was submitted, to say, okay, you stand a chance, or you stand no chance at all. But it's not something I can guess. I can't just say, oh, 50-50, Hi, Macedona from Washington State. JD Mangum says, yes, I'm sorry, it is an I-751. Can I travel outside the country with that 1-year extension? So the answer is yes, but it depends. Because you personally, I don't know your personal situation. So what I mean by that is that if you filed, let's say you filed your green card, removal of conditions on your green card late, the first thing I would want to do before I give a client of mine a legal advice to travel or not is pull their information in EOIR to confirm whether or not there's any kind of notice to appear in front of an immigration judge. If there's any kind of notice to appear in front of an immigration judge, my answer is always no, heck no, do not go outside the country. If there's none, you can definitely leave the country and come back because, again, your 1-year extension, you're still very much a green card holder. So you will have to know what your situation is and whether or not there's any NTA out for you before you make that decision. I can't give you that legal advice. If, you know, or whatever, you can schedule a consult with me and I can help you pull it up and check. Hannah says, good morning, sunshine. I'll continue to pray and I know that God is in control. Amen. Yes, God is in control. Listen, anything's impossible. You know, I'm a woman of faith. I believe that God can make the impossible possible. If this rule passes, listen, guys, it's going to be amazing. Let's see. What else do we have here? Oh, so somebody's asking, what are some next steps after K1 notice of action? I did research, but I don't want to miss anything. How much longer in the process? Well, it depends. It depends on what exactly you have. You just kind of have to wait. And it depends on your consulate. So a lot of times the consulates determine when your fiance will be scheduled, you know, if you've done everything else that you need to do. And that is not in our control. I cannot estimate for you because I don't know what your country or the country is. You know, obviously there's a lot of delay. You know, some countries, you know, are backlogged from the initial ban from last year, plus the travel ban. So, you know, it's really there. But, you know, as long as you've given all your contact information, you should be alerted once anything changes, okay? Akin Remy says, hi, please, I have one question, please. If this reconciliation bill passes, can we vow a pending be of benefits? The answer is that it depends on what's in the bill, but likely yes, if you don't have any status. And the reason why I say it depends is I can't tell you what I haven't, what hasn't passed. Do you understand? Like, so there is a, so we won't know until we know what bill is approved. And then when we know what bill is approved, I will be able to read it and then translate it to you to tell you who it covers and who it doesn't cover. But just keep in mind that those who don't have status, if the bill passes, the idea is to create a path for you to status. And as of right now, what they've introduced in that path is 5 years. Sorry, did I say 5 years? 3 years in a temporary path, which is like almost like a temporary protected status path. You get your green card as long as you continue to pay your taxes and no criminal records. You know, 5 years later, you'll be eligible for citizenship. So that's the path. So, you know, we'll see what happens. Okay. So Dorcas asks, I have a 2-year-old nephew in Angola, which I want to adopt because my aunt passed on last month with cancer. Currently, the child is a nanny. What can I do to keep the child? Well, I'm very, very sorry that you're on pass, but you're going to have to look at the adoption laws, you know, of Angola, you know, to do that. You know, it's a part of the Hague Convention. You know, you got to follow the laws of the state of adoption. So I won't be able to advise you what the adoption laws. Once you adopt your child, you know, in Angola, there's usually like a 2-year residency requirement, meaning that, well, 2 years spent with the child, meaning that you have to go back and stay with the child for a total of 2 years. And 2 years doesn't all have to be all at the same time. It can be like, well, you know, you go, you stay for 5 months, you come back, you go, you stay for 5 months. You can do that. Or you could process an adoption through the United States, which is different, which requires, you know, site visit, home visits, and all of those things. It's too long a process to discuss here, but the first thing you have to do is find out what Angola's laws are on adoption. Alex says, my I-765 is 3 months from expiration when it got lost. I filed for renewal and got the receipt notice of action. I have job offers now and they demand to see before I can get employed. Are you asking if you can make your stuff go expedite your renewal? The answer is unfortunately no. you're at the mercy of USCIS for your work permit renewal. And it also depends on the kind of work permit that you have, you know, because a lot of times your work permit, your receipt notice usually will state that this will act as a temporary confirmation of your work permit and can be used up to 120 days, 180 days. So you want to check your receipt and see that, okay? So Sandra says, good morning. I have a 2-year green card. I have to remove the conditional offer off the green card before I can file for my daughter. She's 20. Actually, Sandra, no. You can actually, if you're a conditional green card holder, you can file for your child just as a green card holder. And Sandra, with you, because your daughter is almost 21, which will change her requirements, you want to file stat. What I mean by stat is today. You want to file today before she turns 21 because it's going to change her waiting time from an immediately available visa to a 5-year wait time. So you chop, chop. You want to do that right now if you are. So yeah, you can definitely do the same thing, file, and then one day remove your condition on your green card, then that's great. But as a conditional green card holder, you can definitely file for your child. Okay, so let's see. You're welcome. Let me see. All right, guys, I think I'm going to jump off. Somebody's asking, does the beneficiary have to interview for the K-1? Absolutely, yeah, they do. You know, they're going to be interviewed for their K-1 visa in their home country once it's moved over to the consulate. All right, I think I answered all the questions that I can see. Okay, guys, I'm going to tune in again live tomorrow around somewhere between 9 and 9:30. So, you know, you can tune in then. And any questions I didn't get to today, I'll try and answer them. All right, guys, I hope you have a very productive day. Bye.